Hello students, hope you are doing well. Myself Dr. Harpreet Kaur from Army Institute of Law. I will be discussing the topic of analysis of the Child Labour Prohibition and Regulation Amendment Act of 2016. Introducing the topic, we will start with the meaning of term child. The term child is considered equivalent to the universe for parents. Children are the source through which humanity exists. They are the most prone category to exploitation and abuse, both physical as well as mental. A child is deprived of the basic needs and facilities of education and health, which are significant for the growth and development of a child. Child labour has been in practice since ancient time and it was considered as normal. The Indian Constitution lays emphasis on the fact that no child below the age of 14 is allowed to work in any mine or factory as per Article 39 of the Constitution. A child should not be engaged in any sort of dangerous employment. But still for many years, child labour has remained the biggest problem in the path of social development. In present times, child labour is the most crucial and detestable form of violation of a child's right. The exploitation of the rights of children is not a recent issue, but has now gained momentum with the growth of human rights. Many international organizations like International Labour Organization, UNICEF etc. are working dedicatedly to protect the interests of children and facilitate them with basic amenities like education. Article 21A of the Constitution deals with compulsory education for children. The Government of India had promulgated the legislation of the Child Labour Prohibition and Regulation Act of 1986 to regulate provisions related to child labour practices in India. The government made substantial changes in the provisions of the Act in year 2016, and from there on a complete prohibition has been imposed on employment of children who are below the age of 14 years. Many provisions have been made under the Act regarding the employment for the children who are above the age of 14 years. Child labour is a socio-economic problem and it is one of the challenges for a developing nation. To handle this challenge, the government has provided many constitutional as well as legal rights. However, the key issue of child labour has not been addressed properly. The government in year 2016 adopted the progressive approach and amended the Child Labour by introducing Child Labour and Prohibition Amendment Act of year 2016. The Act received the President's assent on 29th of July 2016. However, still the loophole exists in the recent Act. Coming to the Child Labour Prohibition and Regulation Act of 1986. The Act aims to eradicate any kind of child abuse in form of employment and prohibit the engagement of children in any kind of hazardous employment who have not completed 14 years of age. The Act prohibits the employment of children in certain occupation and processes. The occupations which are prohibited are mentioned in the Act under the schedule in Part A. The prohibited occupation for children under 14 years, such as occupations that are related to the transport of passengers, goods or mail by railway, cinder picking, clearing of an ash pit or building operation in the railway premises, working in a catering establishment which is situated at a railway station, and if it involves moving from one platform to another or from one train to another or going in or out of a moving train, etc. Prohibited processes for children under the age of 14 years are mentioned under the schedule in part B. They are process involving the making of bidi, process which involve carpet weaving, manufacturing cement or bagging of cement, process such as cloth printing, dyeing and weaving, etc. The Act in total prohibits approximately 13 occupations and 51 processes for employment of children. Article 24 of the Indian Constitution includes the provision for the prohibition of employment of children in factories. The Act also lays down certain guidelines for employers which is to be followed in case the employee is a child of age less than 14 years. According to the Act, the employer cannot make a child employee work between 7 p.m. and 8 a.m. and no overtime is allowed for them. It is not allowed for an employer to make a child work for more than 3 hours without an interval of at least 1 hour, and in total an employer should not make a child work for more than 6 hours a day. Adequate provisions must be made by the employer for the health and safety of the child employees. Basic facilities such as drinking water, toilet, disposal of waste, ventilation, etc. must be provided by the employer. The employer need to notify the factory inspector if in case he employs a child for employment. Production of a certificate of the child employee is also needed according to the rules of this Act. Coming to the Child Labour Prohibition and Regulation Amendment Act of year 2016. The Act was amended in year 2016 and some new provisions were brought in it. The Rajya Sabha passed the bill to amend the Child Labour Prohibition and Regulation Act of 1986. The bill was passed on 19th July 2016. The amendments were made to make sure that the education of children between the age of 6 to 14 years is not compromised at any cost. The amendment was made to bring the old Act in line with Free and Compulsory Education Act of 2009, and the name of the Act is Right to Education Act. As per the amendment, there will be stricter punishment for employers who violate the Act and its guidelines. The offence is cognizable if an employer employs any child in contravention of the Act. The amendment covered the 18 occupations along with 65 processes of the 1986 Act. The punishments and imprisonment tenure were also amended and they were made stricter. The amendment completely prohibits the employment of children below 14 years of age. Only those who have their own family business can work, given their education and health are not hampered. The Act also creates a new segment of adolescent for children between the age group of 14 to 18 years of age and prohibits them from being employed in hazardous activity and occupations. After consultation and discussions with the stakeholders, the government again amended some provisions of the Act in year 2017. The provisions were added under the Child Labour Prohibition and Regulation Amendment rules. To protect the interest of children and adolescents, a broad framework was made for prevention and prohibition of children from labor. More clarity was given with respect to the family provision that was added by the amendment of 2016. To ensure the effective and efficient implementation of plans and policies, a set of duties and responsibilities for the agencies were added to this Act. An analysis of the new amendment has shown that the list of 83 prohibited activities has now been cut down to only mining, explosives and the occupations mentioned under the Factories Act of 1948. As per Section 4 of Child Labour Act of 2016, the government can at its own will remove any of the listed hazardous activity. Significant features of the Amendment Act of 2016 are as follows. First, there is a change in definition of term child. The definition of term child was amended in order to bring it in sync with the Education Act. The Act defines a child as an individual who has not reached the age of 14 years. However, this definition was given from the definition given under the Factories Act 1948. Secondly, there is a new definition of term adolescent. The Amendment Act introduced a new term adolescent. The previous Act even did not talk about this term. The term was defined as an individual who has completed 14 years of age, but is below the age of 18 years. In simpler words, children between the age group of 14 to 18 years were categorized as adolescent. The definition of adolescent in the Factories Act is slightly different from this. Third, the Act has a ban on the child labor. An entire ban on child labor has been imposed except of the following two cases. Children are allowed to assist in the family enterprise given that their work is done after school hour or during the vacation period. Also, the activity should not involve any hazardous processes. Children are allowed to advertise in audiovisual businesses as long as their education and health are not compromised. Fourth change is the cognizable offence. Child labour is made a cognizable offence. The investigations into the matter could commence without a writ and arrest can be made without a warrant. Sixth change is in the punishment. The punishment of the employer have been increased, whereas guardian's punishment have been relaxed. The amendment have been made in the long title and short title of the Act. Substitutions were made in Section 3 of the Act. Section 3A was recently inserted into the Act. Significant amendments were made to Section 14 and 18 of the Act along with the substitution of a new schedule. Now, what are the loopholes in the present Act? Loopholes of the Act. There are many provisions which are welcomed. However, all key changes are not acceptable and it leaves many drawbacks. The amendment changes the definition of parents and has broadened the term which is a concern in itself. This definition is in contravention of the Juvenile Justice Act 2000, which makes it punishable for anyone who employs a child in hazardous occupation. Furthermore, it is also in contravention of International Labour Organization, the Minimum Age Convention and UNICEF Convention on Child's Right. Here, it is also notable that India is a signatory of all the conventions mentioned above and hence it has also a binding effect. Furthermore, Section 3 to 5 of the Child Labour and Prohibition Amendment Act of 2016 allows the children to work in the family enterprises. However, the drawback of these sections is that the legislation has not defined the hours of the work with the family. This will definitely defeat the purpose of the legislation. The children will be engaged only to traditional work, and this can lead to a hamper on his education. The legislation must have to frame the time limitation for these sections. Furthermore, the legislation itself permits child labor. However, it is subject to certain conditions. But the thing is that the conditions imposed are easily vulnerable. The permission to work after the school hours will definitely impose an additional burden on the child, both physically and mentally. Moreover, this is also in contravention of Article 21 of the Indian Constitution, which deals with right to good health. Moreover, Section 14 Clause 3 talks about compounding of offences committed for the first time or an offence committed by a person being parent or guardian on payment of such amount will lead to encouragement to violate the law. Furthermore, the list of hazardous occupation for children has been reduced from 83 to 3, which only includes mining, explosives and hazardous processes. This concludes that the work on chemical mixing units, cotton farms, etc. has been dropped. Furthermore, in India, a large number of people are dependent on agriculture. The legislation permits to work there. Therefore, it may lead to the defeat of the legislation, as the children at a large scale may be involved in this work. While this amendment with respect to normative epistemology, which has been enacted in consonance with RTE Act, is certainly welcome, the 2016 Act, however, does not appear to have accounted for the provisions of the Juvenile Justice, Care and Protection of Children Act 2015, wherein the age of the child is defined as below 18 years. Similarly, India being a signatory to the UNCRC and duty bound to be guided by it and implement the various provisions, the present Act should have taken children as mentioned in Article 1 of the UNCRC, which says a child means every human being below the age of 18 years unless under the law applicable to the child majority is attained earlier. By retaining the age limit of 14 years under the 1986 Act, the 2016 Act fails to streamline extant legal threshold for determination of age of children, thus further obscuring the legal threshold with respect to this issue. Further, in the light of the Right to Education Act, the 2016 Act seeks to prohibit employment of children below 14 years in all occupations. However, such employment is not prohibited where the child helps his family or a family enterprise, which are not hazardous occupations after school hours or during vacations. Notably, the import of family under the 2016 Act is taken to include not only the immediate nexus of the family, such as the child's parents and own siblings, but also comprises the siblings of the parents as well. The definition of family enterprise is analogously broad ranging, as it includes any work, profession, manufacture or business which is performed by the member of the family with the engagement of other persons. Here, 2016 Act has been criticized as impervious to the grim empirical realities of rampant child labor in the Indian context, since by couching these definitions of family and family based enterprises in unduly wide ambits, it leads to further perpetuation of child labor in family-based enterprises. This is owing to the discernible reason that labor of the children is insidiously outsourced to family-based enterprises, especially where no other alternatives are readily available to children. The 2011 census result also stated that 33.9 million children are out of school and vulnerable to labor. Further, around 1.01 crore children in the 5 to 14 age group earns for their family. They will not be protected under the amended law. Thus, the 2016 Act remains oblivious to aspect of the problem of family-based enterprises. The family members serve as access points for child labor in a majority of cases, and consequently therefore that there is a grave and urgent need for punitive prohibition on solicitation of child labor by family members themselves. Furthermore, it has also been ignored that children working in such family-based enterprises might be involved in a range of activities which place demands on a child's physical and mental health as strenuous as activities in other sectors. These enterprises often entail involvement in physically and mentally taxing travails such as embroidery work, carpet weaving, bangle making, beady rolling, etc., being forced to work at odd hours, being exposed to the threat of sexual, physical and emotional exploitation, for example, domestic child labor, work in agriculture farm, exposure to significant health hazard in certain occupation, for example, food processing, chemical industries and brick kilns, and socio-psychological distress due to migration, for example, seasonal migration, migration for agriculture related work in sugarcane, cotton and soybean industries. This evinces the ample scope for pervasive exploitation even within the family-based enterprises. In addition, the misuse of this provision by contractors to discuss child laborers as simple assistant to adult family members in most outsourced activity cannot be ruled out. Thus, contractors have the opportunity to pass on higher quantum of work to children at considerably low wages, accentuating ill treatment of the children. Critics also argue that this provision reinforces caste-based occupation since most family enterprises are caste-based, especially in the rural India. This only serves to further ratify antiquated notions of socio-economic segregations, ascription of social status by birth and the precipitate exclusion of future generation from productive human capital. By normalizing and institutionalizing child labor in family-based enterprises, the 2016 Act fails to ameliorate the numerous advertises affecting child belonging to disadvantaged socio-economic background and inhibits their potential to overcome these difficulties concomitant with their unfortunate circumstances. Despite having a fundamental right to education, therefore, these children are inevitably forced into a situation where familial pressure to join the family occupation trump access to knowledge and prospect of emancipation from their backgrounds. Notably, the 16 occupations and 65 processes that were listed as hazardous in the 1986 Act have now been replaced by merely 3 occupations and 29 processes mentioned in the Factories Act of 1948, which covered only the organized sector. The redefining of hazardous occupation and processes has made a range of occupations like domestic labor, work in bricklines, handling chemical insecticides in agriculture, gem cutting, work in slaughterhouse, carpet weaving, cotton ginning, stone breaking and crushing, tire retreading, etc. non-hazardous for the children. Therefore, the 2016 amendment is silent on issue arising as to rights of children engaged in hazardous occupation in unorganized sector. The gap left unaddressed by the 2016 Act could prove severely detrimental to the regulation of the child labour in the unorganized sector. Further, the report of the Standing Committee on Labour 2013 has also recommended that the meaning of hazardous occupation and processes should be widened to include all those occupations and processes that may jeopardize health, safety and morals of the adolescent in line with the International Labour Organization Convention 1938. Moreover, recent NCRB data shows that around 25% of children raped were targeted at work by their employers and the co-worker. Since the 2016 Act prohibits employment of children in all occupational processes, the power to make periodic inspections of places of employment reposed in the appropriate government should not have been limited to hazardous occupation only and should have been expanded to cover all places of work and occupation. Nonetheless, the 2016 Act appears oblivious to these pressing concerns. The second exception under section 3 clause 2 subclause B of 2016 Act states that such employment of children is also not prohibited if they work in audio visual entertainment industry, which would include advertisement, films, television serials, sports activities at all. However, the rationale for offering such exception with specific regard to the listed activity is not clear. As pointed out in 2013 report, there is no compelling reason why the prohibition of employment of children in a subordinate relationship of work and labour should not extend to those working in audio visual entertainment industry. The committee observed that in recent time there is an increasing trend of employment of children and adolescents in this industry, and there have been cases where the children have not been able to bear the physical and mental trauma associated with rigorous routines involved. Therefore, the exception should have been removed altogether so as to include children working in the entertainment industry within the ages of protection afforded by the 2016 Act. In the light of aforementioned concerns, the committee had furthermore specifically recommended that all such exceptions should be removed and that employment should be prohibited in all occupation where a subordinate relationship of work and labour exists. However, these recommendations were wholly ignored. Ostensibly, at first blush, it appears that section 3 clause 2 may be cognizant of some of these dangers to a limited extent, because it also states that the aforementioned exceptions will not apply if any labour undertaken by the child in pursuance of working in the family based enterprise or the audiovisual industry affect the school education of the child. This proviso is, however, virtually ineffective, since it is realistically very difficult to monitor whether the children are indeed working in their homes and to check whether they are helping their parents or working to supplement the family income. Further, the proviso does not lay down any threshold or standard by which it may be possible to assess the impact of the pursuance of child labour in the designated spheres on child's school education. Questions such as who will assess whether the child's education is being impaired are also left as unaddressed. Section 17A inserted by the 2016 Act empowers the district magistrate for ensuring the implementation of the provisions of the Act. However, as is clearly evident, it is neither feasible nor realistic for one individual to monitor whether the children's education is being inhibited, let alone deal adequately with the issues of child labour that do enter the legal arena. Cognizant of immense burden on the district magistrates to dispose the cases, the 2000 report accurately identified that they may not be able to spare the times to appropriately dispense justice in each individual instance of violation of 2016 Act. Therefore, the report had recommended the constitution of vigilance and monitoring committees headed by local members of the parliament to review implementation of the Act, who would be acting under the aegis of the district magistrate for the final enforcement. However, these suggestions were not heeded in the formulation of 2016 Act. Furthermore, an important aspect that appears to have escaped the notice of the legislature is that these ostensibly child-friendly provisions can be misused to render some form of child labour. For instance, in the entertainment industry, which is completely invisible. This may end up further marginalizing vulnerable children working in these sectors, who would then be faced with prospects of irregular school attendance, lower level of learning and higher dropout rates. Thus, the exception only precipitates exclusion of the most disadvantaged children who needs education, which is now their fundamental right under Article 21A of the Constitution. It may further be noted that the rescue of the children and adolescents who are employed in contravention of the provisions of 2016 Act and their subsequent rehabilitation are governed by a plethora of laws and therefore require timely coordination among various ministers such as those of Labour, Human Resource Development, Women and Child Development, Home and Rural Development et al. Such multi-stakeholder engagement necessitate the formulation of a comprehensive child labour policy, which eschews a fragmentic approach as adopted by 2016 Act and instead lays down detailed procedures and guidelines for the implementation. This would facilitate consolidation of the varying schemes under different laws for the rehabilitation of those children and adolescents. Thus, it can be inferred that considerable shortcomings plague the normative scheme as well as implementation framework of 2016 Act. These ambiguities and lacunas need to be readdressed at the earliest so as to ensure that the objective of child welfare and development are holistically achieved. Coming to the conclusion of the topic, the Child Labour Prohibition and Regulation Act of 1986 prohibits children from working in hazardous employment. The Act provides a minimum age for the employment as 14 years. The prohibition of the Act has helped in reducing the rate of child employment in India. It has reduced various hazardous risks to which child employees are exposed at the workplace, as well as the exploitation by laying down the provisions for maximum numbers of hours or period of work and various other related issues. The Act has played an important role in reducing hazardous employment for children in India. If it is found that the employer is employing a child in contravention of the provisions of the Act, then such employer will be liable for punishment, which include imprisonment or fine or both. Although the Act has reduced the number of child labours, this evil is still lingering in our society due to the socio-economic issues, that is poverty and illiteracy, and for overcoming the evil of child labour, collective responsibility has to be taken up by the society at large. As Justice Subba Rao, the former Chief Justice of India, rightly said, that social justice must start with the child. Until and unless a tender plant is properly tended and nourished, it has small chance of growing into a strong and useful tree. So, the first preference in the plat of justice would be stated to the well-being of the children. Thank you and have a nice day.